Well, good morning, everyone. I'm Bill Traynor. I'm the Dean of Georgetown Law, and it's a privilege to be able to welcome you to a conversation on criminal justice, a call to action for the nation. At Georgetown, we're very proud that we convene so many important discussions during the course of the year, but this is one that really resonates with the mission of the school. If on your way here you passed the library, you would have seen the motto of the law school, which was over the door of the library: law is but the means, justice is the ends. And so when we have, for example, our criminal law course in the first year, we actually don't call it criminal law, it's called criminal justice. And so we introduce our students at the start of their legal education to many of the issues you're going to be discussing today. And then we continue through with our scholarship. We have scholars like Paul Butler and Allegra McLeod who are focusing in on fundamentally important criminal justice issues. And then we also have an extraordinary legislation clinic, which is headed up by Judy Applebaum, who comes to us from the Department of Justice, who's here today. And among their projects for the year is looking at sentencing reform. So, and this is an important moment. Today's event is part of a discussion which I think has the opportunity for change in a way that we haven't seen in decades. And so at the end of the day, we're going to be having a panel that has Representative Bobby Scott, Senator Michael Lee, Senator Rand Paul, Senator Sheldon Whitehouse. We're going to have an extraordinary discussion of some of the leading thinkers and leaders in the area of criminal justice. And we're going to have a keynote address to begin the day by an extraordinary leader of our nation, our Attorney General. So we'll be hearing from Eric Holder in just a few short moments. So it's been a pleasure to work on this. It's a pleasure to host this. And we look at this as an opportunity to deepen our ties to the Vera Institute. And so after me, we're going to be hearing from Nick Turner, who's the president of Vera. So round of applause for Nick. And then we're going to be hearing from the inspirational and really visionary Wade Henderson, who's the president of the CEO Leadership Education Fund. So Wade. So welcome all. It's going to be a day of very important discussions. And without any further ado, let me bring Nick up to the podium.
Good morning, everyone. I'm Nick Turner. I serve as the president of the Vera Institute of Justice. It is an absolute honor to be here today with all of you and to be able to look out on this crowd of distinguished guests and participants, people who we have collaborated with for a long time. And I can't stop but think about what a remarkable opportunity we have. This is a chance for us to reflect on our nation's justice system and contemplate major challenges that remain before us. Because as we know, for far too long, our criminal justice system has resulted in egregious disparities for some of the very same people and communities that we will increasingly rely upon to fuel our nation's prosperity and growth. As we know, this country will become majority-minority in about 30 short years. 30 years seems like a long time to us sitting in this room, but it is a blink in the eye in the demographics of this country, and it is a huge challenge. The administration and Congress, as we know, are poised to take on these inequities and to embrace meaningful reforms that could stem the historically inefficient and unjust and sometimes overly broad practices in our criminal justice system. And I really believe that this dialogue can support and strengthen these efforts. With that in mind, first and foremost, I'd like to recognize our nation's top law enforcement officer and the steward of our constitutional rights and responsibilities, the Attorney General, Eric Holder, and thank him for taking the time to be with us today. At Vera, we were fortunate enough to hear his goals and priorities 5 years ago when he spoke at our annual Justice Address. And it's good to be with him again, to be able to hear about his current goals and priorities and the activities that are part of the Department of Justice's Smart on Crime initiative. Given the timeliness and the importance of today's conversation, I'd like to thank, of course, Dean Traynor for hosting us here at Georgetown University Law Center. This is a wonderful institution. We couldn't be luckier to be doing this event in this space, and it certainly befits the importance of the institution for policy discussions that we know happen in DC and the important ones that truly matter. I would also like to thank my longtime friend and collaborator, Wade Henderson, and the Leadership Conference for Civil Rights. I will say that back in October, when Wade and I decided to get together for breakfast to talk, and I wasn't quite sure about what. As you may or may not know, I am the newish president of Vera. I've been around for about 6 months, but for the past 6.5 years, I was at the Rockefeller Foundation, and I was lucky enough to support the Leadership Conference. And I thought, well, Wade, that's a class act. You know, he doesn't need to be paying me any more attention because I don't provide the grants, and he wants to have breakfast. What a nice thing. And it turned out that Wade had this remarkable idea for Vera and for the Leadership Conference to partner on this event, and I'm sure to partner into the future. And we're very lucky to be doing this with you, so I want to thank you. Today, we're also going to hear from a wide range of voices representing diverse perspectives from the ACLU, the Heritage Foundation, the Aleph Insitute, and the Justice Fellowship. And we ask all of you, and we know we don't need to ask because this is what we'll get, to engage in a very robust dialogue where we hopefully can find common ground to achieve real action and meaningful reform of our criminal justice system. For those who are in the room and want to make sure that others get a chance to participate in this discussion, we'll be live tweeting this event to engage those who are not here. And so what we'd ask you to do is to live tweet at your, at your abundant most, and it's hashtag #TalkCrimJustice. So I also want to just take a brief moment to thank all of you in the audience. I know that all of you took time from very busy schedules and had to brave the subarctic polar vortex that seems to have settled over this part of the country for about the last 6 weeks. But I know that there are people from Capitol Hill and from the Justice Department and many people from dedicated organizations that we know are working very hard every day to prevent crime and to improve public safety and to strengthen common sense policies. I also want to say that I am slightly relieved that my parents are not in this room. I was born and raised in Washington, D.C., and I saw that my brother-in-law had RSVP'd, and that sent a shudder down my spine, but that my parents would be soon to follow, but they are busy wintering in Sarasota, so no one is going to raise a hand and call me Nikki, which is my diminutive nickname, although actually now that I said that, I worry that maybe some of you might. A few last things. This is it's a really auspicious moment, and it's hard not to be reflective. Like I said, I was born and raised here in Washington, and before I became a lawyer and went to Vera and the Rockefeller Foundation, I worked for a nonprofit called the Sasha Bruce Youth Work. And I worked with young people who were court involved, young people who had given up on school and who had turned to the drug trade. And those years from 1989 to 1993 were very, very different years than the period that we're in right now. I think at that point, DC was considered to be the murder capital of the country. The homicide rate was extraordinarily high. There were carjackings, the very common occurrence, and there was a great deal of sort of a lack of hope. And I remember working with young men who it seemed almost determined, despite the good work that we were doing at Sasha Bruce, that their life courses were almost predestined for them. I think at that point in time, the Attorney General was on the Superior Court bench here, it's a remarkable thing to stop and to pause and to see where we have come in those 20 years. It is also a remarkable thing when we stop and think about something else that happened 20 years ago, which is that the 1994 crime bill was passed. And that was very comprehensive legislation that all of us who are doing this work today operate within the construct of. The Violence Against Women's Office was created. The COPS Office was created. The federal government provided incentives to states to change their laws and to assist in the building of prisons. And when we now stop and look at where we are and the Justice Reinvestment Initiative and the Smart on Crime Initiative, it is a very different world. And so over the course of the next year, Vera will be holding a series of symposia here in Washington to reflect on some of the changes that we've seen in the past 20 years, to ask what we did well and to ask what we could do better and to ask what we should do for the next 20 years to have a justice system that is efficient, that provides public safety, that gives people an opportunity to pursue their economic mobility, and that puts the country on the right track. You will see, I think, as you know, the Senate Judiciary Committee is spearheading this review to federal sentencing laws, and the House, we know, is leading an effort regarding over-criminalization. And so Vera will continue to try to do its part to participate in this conversation. If you look in your packets today, you will see that we have produced a brief that looks at how states have dealt with mandatory minimums over the past decade or 12 years or so, identify some of the trends and the practices. And we'll also have a series of publications that will be coming out to look at collateral consequences. And finally, in a few months, we will take a very close look at what we think of as a natural experiment. As there has been this movement to reform mandatory minimums, one of the places where this occurred that received great prominence was in New York State with the reform of the Rockefeller drug laws. And so we have looked very closely to see, with the aid of the Department of Justice, the National Institute of Justice, what the effects have been in terms of outcomes for people, in terms of spending, in terms of racial disparities. So keep your eye out for all of those things. So I'm sure we will be exploring many of these topics again over the course of the day, and I'd like to turn the podium over to my good friend, Wade Henderson, to kick off what should be a very timely conversation.
Good job. Good morning, everyone. As you've heard, I'm Wade Henderson, President and CEO of the Leadership Conference Education Fund, an organization committed to building public will for federal policies that promote and protect the civil and human rights of all persons in the United States, and the Leadership Conference on Civil and Human Rights, the nation's premier civil and human rights coalition working to build an America as good as its ideals. I'm also proud to serve as the Joseph L. Rao Jr. Professor of Public Interest Law at the University of the District of Columbia's David A. Clark School of Law, and so I especially appreciate this collaboration today with Georgetown and with the Vera Institute. I want to thank the Dean of Georgetown, Dean Traynor, for hosting us today. I want to thank my colleague, Nick Turner, for his support of this effort and for his collaboration. I have the great pleasure of introducing U.S. Attorney General Eric Holder, our nation's top law enforcement officer and the first African American in our nation's history to hold this important position. General Holder has had a diverse and distinguished career that touches nearly every facet of the law. From his work as U.S. Attorney for the District of Columbia to his service in the Clinton Justice Department as Deputy Attorney General, to his time as the Associate Judge of the Superior Court of the District of Columbia, and his work with the NAACP, Legal Defense and Educational Fund, and service in the prestigious law firm of Covington and Burling. He has done it all. Now, as many of you know, in August of last year, General Holder announced the new Smart on Crime initiative, which is part of an ongoing effort to modernize the criminal justice system by shifting away from an over-reliance on incarceration. We were pleased to see the Attorney General take on this issue and use his leadership to find ways to enforce our laws more equitably and humanely. And that commitment continues with the recent announcement of a formal executive clemency process for individuals incarcerated with overly punitive sentences. We are so honored that General Holder has come to speak with us today about the Justice Department's initiative promoting criminal justice reform and the great importance of creating a system that is more just, more humane, and more efficiently administered. Ladies and gentlemen, please join me in welcoming U.S. Attorney General Eric Holder to the podium. Thank you so much.
Thank you. Thank you. Thank you. Well, good morning. And thank you, Wade, for those kind words. I didn't hear any of them. So were they kind? All right. Can I get a copy, Wade, of your remarks? I just, want to check there, see if they're factually accurate. I want to thank you all for being here. I see lots of old friends who I've done many battles with. It's good to see you, Judy. It's a privilege to join so many criminal justice leaders, so many policy experts, public servants, and aspiring legal professionals at today's forum. And it's a pleasure for me to be back here at the Georgetown University Law Center. I'd like to thank my longtime friend, Dean Traynor, Nick Turner, along with their colleagues from the university, the Vera Institute of Justice, and the Leadership Conference Education Fund for hosting what I think is a really important discussion and for bringing this really remarkable group together to confront some of the most complex and urgent criminal justice challenges of our time. Today, we gather in recognition of the fact that although our laws and procedures must continually be updated, our commitment to the cause of justice must remain constant. From its earliest days, our republic has been bound together by its really extraordinary legal system and by the enduring values that define it. Now, these values of equality, of opportunity, and of justice under law were first codified in our founding documents, and they are put into action every day by leaders like you, the talented men and women who learn at great institutions like Georgetown, learn what it means to be a steward of the law and an advocate for those whom it protects and empowers. Now, although the issues on our agenda this morning and this afternoon are difficult and at times divisive, the diversity of this crowd and the panelists and members of Congress that you're going to be hearing from is a testament to the fact that criminal justice reform is essentially not a partisan issue. It's about providing legal professionals and law enforcement leaders with the 21st century solutions they need to address 21st century challenges. It's about shaping a system that deters and punishes crime, keeps us safe, and ensures that those who pay their debts have the chance to become productive citizens again. Most importantly, it's about answering fundamental questions about fairness and equality that determine who we are and who we aspire to be, not only as a nation, but as a people resolved to move forward together and committed to implementing criminal justice policies that work for everyone in this country. This is the challenge, but this is also the extraordinary opportunity that brings us together this morning. Now, it's the same challenge that drove me roughly 1 year ago to launch a very targeted Justice Department review of our criminal justice system, to identify areas for improvement and to make this system as efficient and as effective and as just as possible. Last August in San Francisco, I announced a new Smart on Crime initiative. It's based on the results of that review, and that's already allowing the Justice Department to strengthen the federal system, to increase our emphasis on proven diversion, rehabilitation, and reentry programs, and to reduce unnecessary collateral consequences for those who are seeking to rejoin their communities. Among the key changes that we're implementing is a modification of the department's charging policies to ensure that people who commit certain low-level, nonviolent federal drug crimes will face sentences that are appropriate to their individual conduct, rather than stringent, mandatory, across-the-board, mandatory minimums, which will now be reserved for the most serious criminals. As you'll be discussing later today, this change will not only make our system fairer, it will also make our expenditures more productive. It will enhance our ability to combat crime, to reduce drug-fueled violence, and also to protect our communities. And it will complement proposals like the bipartisan Smarter Sentencing Act that is co-sponsored by Senators Dick Durbin, Mike Lee, Chairman Patrick Leahy, along with Representatives Bobby Scott and Raul Labrador, to give judges more discretion in determining appropriate sentences for those who are convicted of certain crimes. Now, as we work with members of Congress to refine and to pass this legislation, my colleagues and I are simultaneously moving forward with a range of other reforms. We're investing in evidence-based diversion programs, like drug treatment initiatives and veterans courts that can serve as alternatives to incarceration in appropriate cases. We're working to target law enforcement resources to the areas where they are needed the most. And we're partnering with state officials, agency leaders, and others, including members of the Federal Interagency Reentry Council that's comprised of cabinet secretaries and leadership from really throughout the Obama administration, to advance proven strategies to help formerly incarcerated people successfully rejoin their communities. After all, at some point, 95% of all the prisoners in this country will be released. 95%. And just as we expect everyone who commits a crime to pay their societal debts, we also expect them to remain sober and crime-free upon their release. We expect them to get jobs and find housing. And we expect them to become more productive, law-abiding members of society. Unfortunately, as you all know too well, these expectations are not always met. Rates of recidivism remain unacceptably high. And that's why the Smart on Crime initiative is driving us to tear down unnecessary barriers to economic opportunities and independence. I've directed every United States attorney throughout this country to designate a prevention and reentry coordinator in his or her district to ensure that this work will be a top priority throughout the country. And I've ordered our law enforcement components, and asked state attorneys general as well, to reconsider policies that impose overly burdensome and unnecessary collateral consequences on formerly incarcerated individuals without meaningfully improving public safety. This is important because we have seen that maintaining family connections, developing job skills, and fostering community engagement can reduce the likelihood of rearrest. And we know that restoring basic rights and encouraging inclusion in all aspects of society increases the likelihood of successful reintegration. Now, we've taken significant steps forward in improving reentry policies and addressing the unintended collateral consequences of certain convictions. Yet, formerly incarcerated people continue to face significant obstacles. They are frequently deprived of opportunities that they need to rebuild their lives. And in far too many places, their rights, including the single most basic right of American citizenship, the right to vote, are either abridged or denied. As the Leadership Conference Education Fund articulated very clearly in your recent report, and I quote, "There is no rational reason to take away someone's voting rights for life just because they've committed a crime, especially after they've completed their sentence and made amends," unquote. On the contrary, there's evidence to suggest that former prisoners whose voting rights are restored are significantly less likely to return to the criminal justice system. Now, as your report further notes, it's very interesting. A study recently conducted by a parole commission in Florida found that while the overall 3-year recidivism rate stood at roughly 33%, the rate among those who were reenfranchised after they'd served their time was just a third of that same rate. Now, unfortunately, the reenfranchisement policy that contributed to this really stunning result has been inexplicably, and I think unwisely, rolled back since that study was completed. And in other states, officials have raised hurdles to be faced by those with past convictions seeking to regain their access to the ballot box. And that's why I believe that today, starting here, starting now, it is time for criminal justice leaders to come together to address this issue. It is time to fundamentally reconsider laws that permanently disenfranchise people who are no longer under federal or state supervision. These restrictions are not only unnecessary and unjust, they are also counterproductive. By perpetuating the stigma and isolation imposed on formerly incarcerated individuals, these laws increase the likelihood that they will commit future crimes. They undermine the reentry process, and they defy the principles of accountability and rehabilitation that guide our criminal justice policies. And, however well-intentioned current advocates of felony disenfranchisement may be, the reality is that these measures are at best, profoundly outdated. At worst, these laws, with their disparate impact on minority communities, echo policies enacted during a deeply troubled period in America's past, a time of post-Civil War repression. And they have their roots in centuries-old conceptions of justice that were too often based on exclusion, animus, and fear. The history of felony disenfranchisement dates to a time when these policies were employed not to improve public safety, but purely as punitive measures intended to stigmatize, to shame, and to shut out a person who had been found guilty of a crime. Over the course of many decades, court by court, state by state, Americans broadly rejected the colonial-era notion that the commission of a crime should result in lifelong exclusion from society. After Reconstruction, many southern states enacted disenfranchisement schemes to specifically target African Americans and to diminish the electoral strength of newly freed populations. The resulting system of unequal enforcement and discriminatory application of the law led to a situation in 1890 where 90% of the southern prison population was black. And those swept up in this system too often had their rights rescinded, their dignity diminished, and the full measure of their citizenship revoked for the rest of their lives. They could not vote. In the years since, thanks to the hard work and the many sacrifices of millions throughout our history, we've outlawed legal discrimination. We've ended separate but equal and confronted the evils of slavery and segregation. And particularly during the last half century, we've brought about really historic advances in the cause of civil rights. And we've secured critical protections like the Civil Rights Act of 1964 and the Voting Rights Act of 1965. Yet despite this remarkable, once almost unimaginable progress, the vestiges and the direct effects of outdated practices remain all too real. In many states, felony disenfranchisement laws are still on the books, and the current scope of these policies is not only too significant to ignore, it is also too unjust to tolerate. Across this country today, an estimated 5.8 million Americans, 5.8 million of our fellow citizens are prohibited from voting because of current or previous felony convictions. Now that's more than the individual populations of 31 United States, 31 of our states. And although well over a century has passed since post-Reconstruction states used these measures to strip African Americans of their most fundamental rights, the impact of felony disenfranchisement on modern communities of color remains both disproportionate and unacceptable. Throughout America, 2.2 million black citizens, or nearly 1 in 13 African American adults, are banned from voting because of these laws. In 3 states, Florida, Kentucky, and Virginia, the ratio climbs to 1 in 5. Now, these individuals, and many others, of all races, backgrounds, and walks of life, are routinely denied the chance to participate in the most fundamental and important act of self-governance. They are prevented from exercising an essential right, and they are locked out from achieving complete rehabilitation and reentry, even after they've served the time and paid the fines that they owe. Now, fortunately, despite unfortunate steps backward in a few jurisdictions, and thanks to the leadership of policymakers from both parties and criminal justice professionals like you, in recent years we've begun to see a trend in the right direction. Since 1997, a total of 23 states, including Nebraska, Nevada, Texas, and Washington State, have enacted meaningful reforms. In Virginia, just last year, former Governor McDonnell adopted a policy that began to automatically restore the voting rights of former prisoners with nonviolent felony convictions. Now, these are very positive developments, but many of these changes are incremental in nature. They stop well short of confronting this problem head on. And although we can be encouraged by the promising indications that we've seen, a great deal of work remains to be done. And given what's at stake, the time for incrementalism is clearly over. 11 states continue to restrict voting rights to varying degrees, even after a person has served his or her prison sentence and is no longer on probation or parole, including the state of Florida, where approximately 10% of the entire population is disenfranchised as a result. In Mississippi, roughly 8% of the population cannot vote because of past involvement with the criminal justice system. In Iowa, action by the governor in 2011 caused the state to move from automatic restoration of rights following the completion of a criminal sentence to a very arduous process that requires direct intervention by the governor himself in every individual case. It's no surprise that 2 years after this change, of the 8,000 people who had completed their sentences during that governor's tenure, voting rights had been restored to fewer than 12. It's 12 out of 8,000. Now, that's moving backwards. That's not moving forward. It is unwise, it is unjust, and it is not in keeping with our democratic values. These laws deserve to be not only reconsidered, but repealed. And so today, I call upon state leaders and other elected officials across this country to pass clear and consistent reforms to restore the voting rights of all who have served their terms in prison or jail, completed their parole or probation, and paid their fines. I call upon experts and legislators to stand together in overturning an unfortunate and outdated status quo. And I call upon the American people, who overwhelmingly oppose felony disenfranchisement, to join us in bringing about the end of misguided policies that unjustly restrict what's been called the most basic right of American citizenship. Now, I applaud those who have already shown leadership in raising awareness and helping to address this issue. Later today, this conference will hear from Senator Rand Paul, who's been a leader on this matter. His vocal support for restoring voting rights for former inmates shows that this issue need not break down along partisan lines. Bipartisan support will be critical going forward because even in states where reforms are currently taking hold, we need to do even more. And we need to make sure that these positive changes are expanded upon and that these changes are made permanent. Virginia's progress has come through the executive power of its former governor rather than the legislature, meaning that without action by state lawmakers, these reforms can be reversed by any future executive with the stroke of a pen. More broadly, the inconsistent patchwork of laws affecting felony disenfranchisement varies so widely between states and in some places between cities and counties that even those who administer the laws are sometimes unfamiliar with how to apply them. It's very interesting. The New York Times noted in 2012 that this kind of confusion means that many who are legally allowed to vote erroneously believe that their rights are restricted. And too often, those who do understand their rights are wrongfully turned away. Today, together, we need to correct this injustice. As the evidence has shown, and as I pointed out in an amicus brief that I signed and filed more than a decade ago in a case challenging Florida's disenfranchisement law, permanent exclusion from the civic community does not advance any objective of our criminal justice system. It has never been shown to prevent new crimes or to deter future misconduct. And there's no indication that those who have completed their sentences are more likely to commit electoral crimes of any type or even to vote against pro-law enforcement candidates. Now, what is clear, and abundantly so, is that these laws sever a formerly incarcerated person's most direct link to civic participation. They cause further alienation and disillusionment between these individuals and the communities that our smart on crime policies encourage them to rejoin. And particularly at a time when our prisons are overflowing, and many who are serving sentences for nonviolent drug crimes find themselves trapped in a vicious cycle of poverty and incarceration, it is counterproductive to exclude these individuals from the voting franchise once their involvement with the correction system is at an end. It is contrary to the goals that bring us together today. And it is not consistent with the cherished ideals that once led Supreme Court Justice William Brennan to call disenfranchisement the very antithesis of rehabilitation. Whenever we tell citizens who have paid their debts and rejoined their communities that they are not entitled to take part in the democratic process, we fall short of the bedrock promise of equal opportunity and equal justice that has always served as the foundation of our legal system. So it's time. It's time to renew our commitment here and now to the notion that the free exercise of our fundamental rights should never be subject to politics or geography or the lingering effects of flawed and unjust policies. After all, at its most basic level, this isn't just about fairness for those who are released from prison. It's about who we are. It's about who we are as a nation. It's about confronting with clear eyes and in frank terms disparities and divisions that are unworthy of the greatest justice system the world has ever known. It's about ensuring that we hold accountable those who do wrong, while preserving the values our nation has always held sacred. And it's about protecting the American people and strengthening our communities while enabling all of our citizens, no matter who they are or where they're from, to make their voices heard. Throughout America's long history of progress, struggle, and sacrifice, as generation after generation has come together to move our nation closer to the ideals our founders envisioned and to advance our pursuit of a more perfect union, this country has always looked to its legal system to answer questions of right and wrong, of truth and justice. Well, this morning, these questions remain before us, and the pursuit of a more perfect union goes on. Although I recognize, as you do, that the progress we seek will not be easy, and the reforms that we need will not take hold overnight, I'm proud to join, and where necessary, to lead this bipartisan group in seeking solutions to these urgent issues. I'm honored to count you as colleagues in the work of forging a more just society that reflects our conviction that all are created equal. And despite the difficulties, the opposition, and the resistance we will undoubtedly face, as I look around this room, I can't help but feel confident in where today's experts and where tomorrow's leaders will take us in the months and years to come. Thank you all very much. Thank you. Okay. Thank you.
Test.
General Holder, thank you for that extraordinary speech. We so appreciate it. General Holder has graciously agreed to take a few questions. And so why don't we start? I'm going to ask you to identify yourself. Yes, please.
Good morning, Mr. Attorney General. Thank you. Nicole and Hillary, Director and Counsel of the Washington Office of the Brennan Center for Justice. Thank you so much for being here this morning. And I think I joined probably this audience who works on these issues and saying thank you for your statement and for your support on this very important issue. The Brennan Center, along with many groups in this room, works on issues of democracy and justice, and the felon disfranchisement issue is one of extreme importance to us. So related to the announcement that you just made, could you elaborate a bit more on how the Department of Justice plans to work with Congress and state policymakers to advance reforms for the formerly incarcerated with respect to their voting rights, and then talk specifically about what, if anything, is DOJ planning to do administratively to advance this issue?
Sure. Well, we'll obviously be interacting with, meeting with, working with members of Congress and state legislators as well to try to put in place statutory modifications to the systems that now exist. As I indicated, it's not enough, I think, to have executive action because we need to have permanent changes put in place. The ability for the federal government to have an impact on state elections is not necessarily as direct as one might want. So I think a lot of this has to be done at the state level. On the other hand, I think that what we do in the federal system can certainly serve as an example for other states. And will also generate conversation about this issue. I mean, the polls show that the vast majority of the American people support the notion of re-enfranchisement, are kind of dumbfounded, surprised when they see the statistics that exist. And so this is a conversation that we need to have that hopefully will lead to positive legislative action. In the federal government, with regard to the Justice Department, we will be supporting those states that engage in these kinds of re-enfranchisement activities, and we'll be doing all that we can as part of our Smart on Crime initiative to make this something that we put front and center.
Why don't we take a question from the young man here on the front row?
Nice bow tie.
Hi, my name is Gabe Coleman. I'm a senior at the Field School, and I know your administration has been really committed to advancing criminal justice policies that seek to address the many challenges in our justice system. And my question is, how can we ensure that these policies survive your administration and then beyond your tenure?
Yeah. I think that goes back to what I was saying before, that it's not enough to have an attorney general who's committed to this. I am. It's not enough to have a president who's committed to this. He is. I mean, that's significant. I mean, when you have the president of the United States stand up for these kinds of issues. But what you need is legislative change. You need this to be codified in our laws. And so I think the fact that you have Rand Paul coming here later on, that you've seen really bipartisan support for what I think are just common sense criminal justice reforms, Republicans and Democrats in the 21st century, in 2014, in Washington, D.C., coming together over an issue. I think that's the kind of change that we need to have. And so I think that's one of the ways in which this has to be made permanent, by legislative change. But beyond that, we have to engage and raise the consciousness of the American people so that they understand why these issues are important. Felony re-enfranchisement among them. How the criminal justice system can be made more efficient, more fair, and we can enhance public safety by doing things differently. You know, the notion of incarcerating our way out of a crime problem is simply something that has been disproved by, I think, all the studies that I have had the opportunity to look at. We are most effective when we deal with the underlying problems that tend to breed crime, when we hold people accountable, but also when we rehabilitate people who are in our system and when we pave their way for reentry back into our communities once they've completed their sentences. And having the right to vote is an integral part of that reentry process.
The Attorney General has time for one last question. A law professor colleague.
Morning, General Holder. Roger Fairfax,
Roger,
professor
how you
at
doing?
George Washington University Law
Well, let's not make like we don't know each other.
First of all, I want to thank you just for your leadership in this area, and I've seen you deliver this message in different contexts: criminal justice policy community, the ABA, the American Law Institute on the Hill, in the community, and you've delivered a consistent and forceful message, and so I thank you again for your leadership. And since we're here at a law school, I what lawyers might be able to do to assist in your efforts in addressing some of the root causes of mass incarceration. I think it was 50 years ago that Attorney General Robert Kennedy issued a call to action to the American bar and asked lawyers to step up and pick up the mantle of civil rights, and the bar responded. And more recently, your Justice Department has worked hard to shine the light on the crisis in indigent defense. and you've asked the bar to assist, and the bar has begun to do so. Is there a similar call to arms that can be issued to the legal profession to help address the problem of mass incarceration? And if so, what would you like to see the legal community do?
Yeah. I mean, lawyers get a bad rap, you know? How many lawyer jokes do we all know? But the reality is that lawyers have always been at the forefront of positive change in this country. It's been lawyers who formed this country, young lawyers at that. And as we have looked at the problems that this nation has confronted and successfully overcome, it's almost been inevitably lawyers who led the way. So I think it is incumbent upon this generation of lawyers, older ones like myself, younger ones who are here, some who are at the field school, that's in high school, and aspiring lawyers, I suppose, to think about how we will confront the issues that continue to bedevil us and that are the issues of our time. It doesn't matter where you work. You know, you can work at a big law firm, big corporation, in the government. You can be a public interest lawyer wherever it is that you work. And I think every lawyer should think of himself or herself as a public interest lawyer and come up with a way in which you can spend at least a part of your day, part of your week, confronting those issues, confronting the issues that we've talked about today, these criminal justice issues more broadly. You can, as I said, raise the consciousness of the nation. You can help legislative change occur. You can spur executive action in the places where you live, here in Washington or the places from which you come. Lawyers can have a profound impact in making our nation more just and making our union more perfect. It is what lawyers do. It's what lawyers do. It's what, we have great power as lawyers. But with that power, I think, comes a great responsibility to give back in the ways that I have described. And individual lawyers should not be so consumed with the pursuit of individual success that we forget that with the training that we have, the unique skill set that we have, we can make our society more fair, more just, more equal. That has to be a part of our consciousness, I think, on a day-to-day basis. Ask ourselves, what am I going to do today? What am I going to do this week to make this country better? In addition to all the other things that we do on a day-to-day basis. It won't be easy. There'll be times when you'll be, you got to get home to deal with the kids and help with homework, and you're trying to form a great relationship with some beautiful young woman that you've just met, some young guy, But there's a way to work around all this stuff to make this positive change possible. As difficult as it might personally be, you will be the better for it, the society will be the better for it, and you'll feel better about yourself. And so I urge everyone in this audience to find that way and not forget that the positive change that we seek exists in the efforts that you all can expend. We expect a great deal. I expect a great deal from you. But I'm optimistic, as I said in my remarks, that if we work together, we can make this nation as wonderful as it possibly can be. Right.
Ladies and gentlemen, please join me again in thanking Attorney General Eric Holder for those extraordinary remarks.
Thank you.
I was told that Representative Bobby Scott from Virginia, a member of the House Judiciary Committee, is here in the audience. Hey, Representative Scott, I think this would be a wonderful time. I hate to put you on the spot, but we've just had an extraordinary presentation by the Attorney General. He's certainly broken new ground in talking about the importance of this Smart on Crime initiative that the department of Justice has undertaken. I know that for many years, you have labored in the vineyards to try to promote a really smart and effective criminal justice reform. I know we don't have you formally on the program, but I wondered if you would be willing to come forward and just share a few observations before we bring the panel into play. Can you do that? Come on up. Come on up.
Thank you. Thank you, Wade, and thank you for all of your good work on civil rights over the years, and the Vera Institute for all the good work that you've done. I've been an elected official for over 30 years in the Virginia State Legislature and in Congress, and one of the things I've noticed is that when it comes to crime policy, you really have a choice. You can reduce crime, you know how to do that, or you can play politics, and we know how to do that. Unfortunately, there's not a lot of common ground right now because the politics of crime is a slogan-based mandatory minimums, life without parole, 3 strikes and you're out. If you can get it to rhyme, it's even better. If you do the adult crime, you do the adult time. That runs about 80% in the polls. The only problem is that it increases crime rather than decreases crime. All of those slogans and sound bites have got us to the point now where we lock up a higher portion of our population than any country on earth by far. Most countries lock up about 50 to 200 per 100,000. Russia's the only thing close at about 500 and some per 100,000. We're over 700 and some per 100,000 locked up today. And to put that into perspective, the Pew Research Center has done some studies. Anything over 350, you're starting getting diminishing returns from locking people up. Anything over 500, counterproductive. You're messing up so many families, wasting so much money that you're actually adding to crime rather than reducing crime above 500. And we're at over 700 per 100,000. So bad the Children's Defense Fund calls it the cradle to prison pipeline. We need to add some common sense because we know what to do. If you have a comprehensive, evidence-based approach to reducing crime, getting young people on the right track, keeping them on the right track, starting early with teen pregnancy prevention so fewer babies are born into dysfunctional families, prenatal care can reduce learning disabilities and mental retardation, nurse visits. The nurse-family partnership has been shown to significantly reduce child abuse, which is highly correlated with future crime. Early childhood education, make sure children can read by the 3rd grade. The teachers tell us up to the 3rd grade, you learn to read. After the 3rd grade, you read to learn. If you can't read after the 3rd grade, you're not learning. You're on the way to dropping out. And dropping out puts you on a trajectory that includes as much prison as anything else. An evidence-based approach to get young people on the right track and keep them on the right track. We know that will reduce crime. And so we're up here doing all these slogans and sound bites, and thank God for groups like the Vera Institute that put some facts, some evidence, and some research on the table. We had a tremendous report on resource officers. Very popular, particularly after the shooting in Newtown. Let's have a police officer all over the place. And the Vera Institute did some research and found that the likelihood that the resource officer would be, these shootings are over in a minute, 60 seconds, 2 minutes, they're done. The chance that the resource officer is going to be at the spot where the shooting occurs is so unlikely. And the resource officer, they have found, doesn't protect the children. They go around arresting the children, getting them caught up in the criminal justice system with all the dysfunction that entails. That they found that the discussion of resource officers is a question of whether it's a total waste of money or whether it's counterproductive. To my knowledge, it's the only study we've seen. And as a direct result of that information, the support for resource officers plummeted. And all of the, in the House, when we came up with recommendations, we came up with support in the schools that did not include police officers in the schools. That's because of the research done by the Vera Institute. So we need to look at things that actually work, and a comprehensive evidence-based approach, getting young people on the right track, keeping them on the right track, which is embodied in the Youth Promise Act that I've introduced, is the kind of thing that will actually reduce crime and save a lot of money in the process. We're also looking at the research that you've done showing the mandatory minimums and how dysfunctional they are. They've been studied. Rand had a study entitled Mandatory Minimums, Throwing Away the Jailhouse Key or the Taxpayers' Money. And they concluded that it was just a waste of money. It requires sentences that are unrelated to the seriousness of the crime, totally disrupts the matrix and common sense in sentencing, often requires judges to impose sentences that violate common sense, just adds to the over-incarceration. These kinds of, and now we have, as a direct result of those studies, the bipartisan legislation that the Attorney General mentioned, where we have a compromise bill that has gotten out of the Senate committee. Unfortunately, by the time they finished the amendment process, they were maybe adding more mandatory minimums than they're subtracting, but at least they're discussing mandatory minimums in a way, and hopefully we can get it back on track where it's actually reducing and not adding. But there's bipartisan legislation in the House and the Senate, and legislation, more extensive legislation that will go right at mandatory minimums themselves, giving the judges an opportunity when a mandatory minimum is in fact unjust, gives the judge an opportunity to sentence in a way that makes common sense. And so I want to thank Wade the opportunity to be here today. Thank you for your work in the Leadership Conference and Civil Rights over the years, and the Vera Institute for helping us make crime policy in a way that is consistent with evidence and research. So thank you very much for all that you do.
Thank you, Congressman. That was a perfect intervention.